Welcome back to Trailblazing Justice. What happens when the law is weaponized to dismantle itself? We're joined this week by Steve Wax, former federal public defender and now senior counsel at the Oregon Justice Resource Center, to explore how legal norms and institutions are being deliberately unraveled. From politicized prosecutions to defiance of court orders, this episode lays bare the calculated erosion of the systems meant to hold power in check. This isn't politics as usual. It's a warning of what can come next. It's all coming up on Trailblazing Justice. This is Trailblazing Justice, episode 60, recorded Thursday, May 1st, 2025. Waxing Confidential, Attack on the Rule of Law. It's time for Trailblazing Justice, the weekly podcast where we discuss civil and criminal rights in Oregon and beyond. Trailblazing Justice is a production of the Oregon Justice Resource Center. And now, here's Bobbin.
Welcome to another episode of Trailblazing Justice. My name is Bobbin Singh. I'm the Executive Director of the Oregon Justice Resource Center. And today we're going to be talking about the attack on the rule of law and talking about the things that we're seeing at the federal level and the Trump administration. I'm excited to have Steve Wax here to speak with us about this. And for most of us in Oregon, Steve doesn't really need any introductions, but we'll go ahead and do a brief introduction. Steve, you want to introduce yourself and who you are and how you came to be in the legal profession, so to speak?
I graduated from law school in 1974, so I am 51 years at the bar, if you will, and actually tried my first case while in law school, so that's 52 years ago. Went from law school to Alaska, clerked for a state Supreme Court, federal, and a federal district judge. From there, back to the borough of my birth, Brooklyn, New York, and worked as an assistant district attorney there for 4 years. It was a fascinating experience, and I had the good fortune to work on two cases involving mass murderers. One, David Berkowitz, the son of Sam, which was quite an educational experience. From there, I went up to Binghamton, New York, a rural area in upstate New York, and served as the county public defender for 4 years. And then came out to Oregon in 1983. I was appointed as the federal public defender. The office when I got here was 9 people. When I retired in 2014, we were 80. When I retired, I actually didn't retire, but I started working with Bobbin the Monday after my Friday retirement and helped launch the Oregon Innocence Project. Have been with OJRC ever since, and in the last months have transitioned from the Oregon Innocence Project to working as special counsel on the issues presented by the current administration and the attacks on the rule of law, the theft of democracy. Along the way, as a practicing attorney, I had the incredible fortune to deal with the terrorism unit of the Department of Justice for the first time in the mid-90s when they prosecuted one of my clients, Rajneesh, for an attempt to murder the United States Attorney for the District of Oregon. And then starting in 2001, within a month of the Twin Towers coming down, the United States Attorney's Office in Oregon brought its first prosecution of an alleged terrorist. And from 2001 until my retirement from the federal office in 2014, most of my work, personal work, was on national security and terrorism cases.
Yeah, and we'll talk a little bit more about those cases and especially or specifically the distinction that you see, what you experienced then versus what you're seeing now. But, not a lot of people are familiar with the court systems, our judicial system, the public defender's office, the state versus federal systems. So can you talk a little bit about what does it mean to be the federal defender for the District of Oregon, and how is that distinguishable from the state public defender system, in which I think a lot of people know is in a moment of crisis, but what are the distinctions there between the federal and state system?
Sure.
And yeah,
Well, under our constitutional structure with governments at the national, state, and local levels, the primary responsibility for prosecution and law enforcement lies with the states and their jurisdictions. In Oregon, the primary responsibility is with the counties. The federal involvement in law enforcement and prosecution has existed from the founding of the Republic, but it has grown exponentially in the last 50 years and really in the last 30 or 40 years. The federal government indictments nationwide are a very small fraction of the indictments that are brought in the state courts. State of Oregon may still have actually more indictments than most of the nation combined in the federal courts. In Oregon, in the Federal Defender Office during my tenure there, the largest number of indictments we saw coming out of the U.S. Attorney's Office was, perhaps 700 or 800. In Oregon, 15,000, 20,000, or more. So very different scale. Federal prosecutions, as a general matter, tend to focus on matters of federal money, federal frauds, but the federal government takes jurisdiction of the frauds when it's not federal money involved, if there is an interstate connection, the mails or the wires. I mean, people may have heard of wire fraud or mail fraud. Well, that's because a person committing a fraud mails a letter or sends something over the internet or in the old days, over a telegraph or telephone. The feds have responsibility for crimes committed on federal land. Periodically, there could be a murder, on a national park. Certainly, drunk driving cases on the national parks would be brought in the federal court. In addition, the feds took jurisdiction over bank robbery cases in the 1930s because of Al Capone and some of the other famous criminals of that era. The banking lobby got Congress to pass a law that if there is federal insurance on a bank, then there's federal jurisdiction. So a state savings and loan that's not a federally chartered bank, that has to be prosecuted in the state courts. So we've seen a lot of bank robbery charges in the federal court here. Illegal reentry cases, in the 1990s, they spiked. We were getting maybe 8 or 10 a year in the 80s and early 90s, and then it went up to 200 or 300 a year. People who have been removed from the country and would come back and have a criminal conviction, then they're prosecuted in the federal court. So, part of what we're seeing with the Trump administration's focus on illegal, immigrants, people with criminal records, that's not new. I mean, that's been going on for decades. And particularly since 2001, the federal government has been very heavily involved in terrorism cases. And those take a variety of forms. There are federal statutes that criminalize what's called, the use of a weapon of mass destruction. There are federal statutes that say, if there is an overseas attack and an American is killed, and this is one of the reasons why Oregon saw involvement, through the Brandon Mayfield case in 2004, the bombings in Spain, 3 Americans were killed in the train bombings in Spain. U.S. has jurisdiction over that type of case. Aiding, a foreign terrorist organization is a federal crime, and there have been a number of prosecutions in Oregon and around the country of individuals and charities for allegedly aiding, designated terrorist organizations. And for whatever reason, Oregon, saw more than its share of such cases from 2001, probably through about 2010. And my office was involved in them, and I was personally, involved in the representation in the Mayfield case, in the Muhammad case, the what became known around town as the Christmas tree bombing case, and there was a fellow who was the head of a local branch of the Al Haramain Saudi charity, which was designated, and that was prosecuted as a tax crime because they couldn't charge something else, but they wanted to get this guy, so they used the tax statutes. Another client was involved with a charity in his home country, Afghanistan, and the government thought that it was nefarious, and ultimately we convinced them that it was not, and that it was just a legitimate charity. So in one other area, the feds get involved, drugs. And for the most part, federal drug prosecutions involve larger quantities, larger dollar amounts, and either interstate or international drug activity. And the states, in the state of Oregon, generally prosecuting somewhat smaller quantities and more locally based crime.
Yeah, so, in Oregon, our work, the bulk of work that we do, as you alluded to, is at the state level, because that's where the vast majority of the criminal system or mass incarceration as we know it exists. So you have county DAs that are elected in each of the counties, sheriffs, local law enforcement. At the federal level, we have the U.S. attorney, the federal defender, and the law enforcement actors are typically the FBI or other federal agencies, and in cooperation with the U.S. Department of Justice, Attorney General's office, right?
Yes, but they also have multi-jurisdictional task forces. The feds are often involved with Portland police and other police agencies and sheriff's agencies in drug investigations. And there are assistant district attorneys who are cross-designated to prosecute cases in the federal court as well. I mean, total number of assistant U.S. attorneys handling criminal cases, I don't know what it is today, but it was 25 or 30, maybe 35. I mean, that's only a fraction even of the Multnomah County, assistant district attorney number, let alone the other 35 counties in the state. It's just another example of the difference. Bob, and you asked another question about the difference between federal and state systems, and with reference to public defense. There's a huge difference, and the difference is really thanks to Lyndon Johnson and the Great Society. Going back to his efforts to address poverty and inequality in the 1960s, one of the laws that was passed was the Criminal Justice Act, United States Criminal Justice Act, which created the federal public defense system in a way that has enabled it up to the present to provide a higher quality of representation, because we're not drowning in numbers in the federal system, because the dollars that are paid to people working in the federal offices tend to be significantly higher than the salaries paid in the state system. When Congress passed the law, they put into it that the federal defender offices were to be staffed at levels comparable to those in the U.S. attorney offices and paid at the same levels. So when I was running the office, I would have access to the salaries paid to assistant U.S. attorneys. And if it seemed as though they had gotten ahead of the assistants working in the defender office, I would be able to go to the administrative office of courts and say, we need to redress the disparity, and we could have our salaries raised. If we were being overwhelmed by numbers, we were able to say we're supposed to be staffed at a comparable level. An assistant U.S. attorney is handling 20 cases a year. We're handling 40, and we would get more staff. That just doesn't exist on the state side. We were also insulated by Johnson from politics. Federal defender system was put into the federal judiciary, and the appointment power was dispersed so that the appointing authority was not the judges in front of whom we appear on a daily basis saying, you're wrong, you're mistaken, you should do this, you shouldn't have done that. Instead, the appointment authority was placed in the courts of appeals, which is much more academic and a step removed. And I was appointed for 4-year terms, I guess 8 of them. And I was retained and would have been retained unless I lied, cheated, or stole, or was incompetent. And there have been defenders who've been fired for incompetence.
Well, that'd be an interesting conversation for a later date as to what constitutes incompetence. But
sure,
it is so the U.S. attorneys, I think people understand it for the most part as a political appointment. So it goes through Senate confirmation, and they act at the direction, or maybe you can explain sort of the influence Main Justice or US DOJ, the Attorney General, and the FBI have on US attorneys' offices across the country. Because this will help bleed into the conversation, I think, about the influence or impact of Trump. So to what extent historically have US attorney's office been independent, having the resources of the FBI versus, perhaps what we're seeing now, which is a little different, or is it different? I don't know, that the U.S. Department of Justice and Attorney General having a heavier hand in sort of the direction of how U.S. prosecutions happen?
There are 2 levels of response to that question. Yes, the U.S. attorneys nationwide are political appointees in the sense that they are recommended by the state senators and appointed through the president. Yes, there is influence on the U.S. attorneys out of Washington. There always is. New president comes in, a new attorney general comes in and puts out a memo. 1989, we had the Thornburg memo, which came out of the first President Bush administration, which took a harder line in a number of areas than had been the case under the Reagan administration. But the reality has always been that the core business of prosecution in a district remains the same. Only out on the margins, has the Washington, politics played a role in shifting things. Thornburg memo, said you have to charge the most serious crime and you have to accept a plea to the most serious crime. Well, the system doesn't work if that's how the U.S. attorneys are going to operate. It would get clogged up. And so in each district, with some exceptions and in different degrees, the system works out how to keep itself going. Things would be a little harsher under that kind of administration, but that harshness would tend to diminish as the administration went into years 3 and 4, just as an example. Chris Olsen, when she was U.S. attorney in the Clinton years, did more archaeological prosecutions than we had seen during the Reagan and Bush years, or the second Bush or Obama years. And that was because of Chris's particular interest in Native American matters. So we saw more. I can't tell you the number, but maybe we saw 12 instead of 4.
Yeah.
Which is really still at the margin of what happens. Today, I haven't been in the office now for 11 years. I'm in touch with Fidel, Casino Declue, who is now the second person running the office since I left, and some of my friends who are still there. They're waiting to see. There is no new U.S. attorney for the District of Oregon yet. What we have seen in other districts where there has been a new U.S. attorney is that this administration is not following the custom of making appointments based on the wishes of the senators. That custom controlled, for the most part, even when both senators were from the opposite party of the president. Or if there was one Repub and one Dem with a Republican president, the Republican and Dem senators would work it out. Maybe one would get the first pick and one the second.
And this, I think it seemed like help ensure or insulate the office to be in the best interest of the state. So the person being nominated, they're tied into people who are connected to the state and are looking out for the state's interest. And, I'm assuming that's sort of the purpose behind having the senators do that sort of process, right?
Sure, that's part of it. And another part of it is the assumption that the senators from the state or the district would know better who good candidates are.
Yeah.
They've got a local ear to the ground. They would have a local merit selection committee here in Oregon for most of the appointments, and you get some people from the big law firms or the Oregon State Bar to help in the selection process. But in some places in the country, that's just out the window. And it appears as though the Trump administration has just put in those people it believes will hew to whatever line he takes, or has Pam Bondi, current Attorney General, take on his behalf. And that's different.
Yeah, and this goes to a question or a commentary that we've heard recently is, historically, the Attorney General in the Department of Justice has largely been independent, and not the president's attorneys or tools of the president to prosecute on behalf of the president. So can you explain that a little bit? And because that kind of goes to this point that you're making about how the U.S. attorneys now are being selected essentially as loyalists, or, people, like you said, will capitulate or advance whatever President Trump wants.
The Attorney General of the United States is not the president's attorney. To be sure, the Attorney General, as with all cabinet positions, is appointed by the president, but his responsibility is to enforce the laws. And he is not supposed to, and historically has not, wielded that power at the direction of the president to go after people. The president says, I don't like this guy. This person spoke against me. This person ran against me. This person was engaged in a prosecution of me. Therefore, I want him fired, or I want him investigated, or potentially I want him prosecuted. And that's different, and that's chilling. Even Jeff Sessions in the first Trump administration, a Trump loyalist who was appointed as Attorney General, got on the wrong side of the president because he refused in one critical area to do his bidding. And what we see today with the people who have been appointed to run the Department of Justice and to run the FBI are people who, it appears, will just do and make whatever argument the president says, or those people who are advising him, because I don't know how much of this actually comes from the president's head, say, should be said. I mean, they're very interesting. The piece was on 60 Minutes this last week, involving it was the National Institutes of Health, but the person who is, had been there for 37 years or something like that, says, in the few short months since Trump's election, the direction that was coming to him, it's just out of bounds. And we've heard from other sources that there are many lawyers, not only from the Department of Justice, but from other federal agencies leaving and seeking employment elsewhere because they're being told to do things and to make arguments that are outside of the pretty broad parameters that the law would accept. I mean, the law is often gray.
Mhm.
Any lawyer knows that. Any lawyer knows that rational arguments can often be made on both sides of a question. But we lawyers also know that there are certain limits that you don't cross.
Mhm.
And in reading about some of the arguments that are being made, in reading the comments that some of the judges around the country are making about the arguments they're hearing, it appears as though the line, the rational parameters are being crossed and arguments are being made. The notion, as happened recently, that a state court judge would be prosecuted by the federal government for obstructing the business of the immigration, ICE, Immigration and Customs Enforcement, because she had a defendant in her courtroom and allowed him to leave the courtroom, not through the front doors where the ICE agents were waiting, that's somehow obstruction of justice and not an intrusion into an area that is primarily the responsibility of the states. That just is, I can't say has never happened, but the idea that that's proper, that's how this administration is going to treat people who disagree with them, while arguments are being made all around the country. And in fact, a Trump judge, a Trump appointee in Texas, just ruled that their use of the ancient the Enemy Alien Act of 1807, I'm sorry, of 1798, to deport, to remove, because you can't even call deport because that involves process, but just to summarily remove people, Venezuelans. They say, well, you're a member of a gang. I mean, a Trump appointee in Texas even said that is not legal. That's not permissible.
We'll come back to this because I
Yes.
think just want to sort of back us up to is we have a situation in which we've sort of abandoned historical practice and culture, in which the president now is directing the attorney general to pursue advance a political agenda by using the tools of the federal carceral system, law enforcement agencies, prosecutors, to go after whatever the president's political agenda is. Previously, this would be unheard of because there would actually be a Congress that could potentially check the president or not permit the U.S. attorneys to be appointed. They would reject these appointments. So without Congress being there as a check, we see, as you mentioned, the court starting to step up. But when we have this dynamic in which the president has the U.S. Department of Justice and law enforcement agencies to be able to advance his agenda, we began to hear these statements, the attack on the rule of law. How has this set up the attack on the rule of law? What from this is flowing that we're seeing through executive orders or actions of the president? You've mentioned a couple already, but like how does that become how we're identifying this now as the attack on the rule of law? But then, the follow-up question to that is, how is that an attack on democracy? Because it's not just an attack on rule of law. The rule of law is sort of the underpinnings of our democracy, or one of the fundamental underpinnings of our democracy. But just starting with that basic question, like, what do we mean by the attack of rule of law, and how is it being advanced at this point by Trump?
That's a very good question, Bobbin, and it's not easy to answer in a couple of words. So
Use
interject
many words.
as needed. So the founding people of this country, all fathers in Philadelphia back then, shouldn't have been, but that's what it was. All white, again, not right, but that's what it was, did understand that to prevent the leaders of the new country they were forming from having the divine right of kings, power, they dispersed the authority to run this country in two ways: federal, national government, and state governments, and under the Constitution, reserving all powers not specifically enumerated for the federal government to the states. Second, they created our three branches of government. They said, all right, well, to prevent a president from deciding to be the king, we're going to have a Congress, and in all of the Article 1, Congress, the first branch of government, all the enumerated, Article 1, section, Congress shall levy taxes. Congress is responsible for passing the law. Congress is responsible for determining, what should happen in interstate commerce. Laws, statutes. Congress passes, the two branches of Congress, again, dividing the power, and the president signs and says, okay, I will now, under my Article 2 power, agree that this should become a law. If he disagrees, Congress has the power to override any veto. They have the ultimate power to say what's the law. Third branch of government, the judiciary, decides when there is dispute what the law means and whether or not a law violates the Constitution. Judicial review. It's been a part of our government structure from the beginning. To be sure, all presidents have operated sometimes with executive orders. Congress, perhaps not so wisely, has given the presidents the authority to act by executive order in certain areas. But absent a congressional delegation of authority to the president to say something by executive order, he doesn't have any inherent authority to do that. He only has the constitutionally given authority to faithfully execute the laws passed by Congress. What is one of the things which causes so many people to say that Trump is assaulting the rule of law, undermining it, and is threatening our democracy is the now 140 some odd, maybe it's now even over 150 some odd, executive orders that he has issued. Executive orders that he says in some instances he has the power to impose because of an emergency power that Congress granted in one area, let's say in 1952 or 1966, but he stretches that. Mm-hmm. And as an example of an executive order which is being challenged and is a direct assault on the rule of law are the executive orders he has issued directed to law firms,
Mhm.
saying to law firms, well, I have decreed that diversity, equity, and inclusion is not the policy of this country. Notwithstanding the Civil Rights Acts and monies that Congress has appropriated for diversity, equity, and inclusion divisions throughout the federal government and requirements, let's say, for example, in contracting with the federal government in order to redress the historic racism and racial exclusion. Certain number of contractors are supposed to be minority business owned. Well, Trump says can't do that anymore.
Mhm.
That's unfair to white people. It's unfair to white people. So he's putting these civil rights laws, on their head. And he says to the law firms, you have to change your DEI policies. You have to get rid of them. You have to get rid of your hiring, your promotion, and I guess there's a third thing, that goes with employment. Or I'm going to say you will not get any federal contracts. He also says in those executive orders against the law firms, I find that you are a threat to the United States of America because, among other things, with respect to Perkins Coie, local law firm, you represented the Democratic Party. You've provided representation to George Soros, who in Trump's mind is a notoriously something, left-wing person who is undermining, his view of what America should be. So because you have provided representation to those people, I call you a threat. Because I call you a threat, I am going to take away all of the security clearances of all of the people in your firm, which prevents them from representing some of their existing clients who have matters pending, let's say, a contract dispute with the Department of Defense. Money, 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 money. Department of Defense and Boeing are arguing about whether or not the wing that Boeing made for an F whatever jet craft met the specifications. Perkins is representing Boeing. Perhaps I don't know if they represent Boeing, but this is an example. And you need a security clearance if you're talking about what metal is in the wing of a jet fighter. You can't do it.
I mean, when we read the executive orders going after the law firms, and many of them, I mean, there's a bunch, some have capitulated and agreed to do the things, that aren't contrary to the executive order. Others are fighting it. But I guess what is the bigger point the Trump administration is trying to do to the law firms and to the legal profession with these executive orders?
The bigger point is that the Trump administration appears to be trying to chill what those firms are doing. That is, to discourage the firms from bringing some of the challenges against the executive orders in, across the board. Whether the executive
other 100 so that don't deal with all sorts of stuff, right? Like
That's right.
funding for health, research, whatever it may be.
Correct. Yeah. So to discourage the law firms from and making it economically devastating for the law firms to undertake representation of clients and causes that Trump personally disagrees with.
And what's just a point, because I do want to highlight, like, these law firms we've worked with do pro bono work, for causes that we care about. It helped us with work representing clients. But going back to, the stuff that you talked about with your national security work with Guantanamo detainees, I mean, it was also some of these law firms that helped with that too, right?
Absolutely. Absolutely. And in
Just to highlight the importance of these firms, like, sorry.
Yeah, they, there were many of the largest firms in the country, and also some smaller firms who took on representation of some of the prisoners in Guantanamo, free out of their own pockets. There were also a couple of firms that were retained. One, big firm was retained by the Kuwaiti government, got millions of dollars to fight against the Bush administration's treatment of the Kuwaiti nationals. And the Trump executive order on the law firms says to those law firms, if you take on this kind of work, you challenge my authority in this way, then the federal government won't contract with you. The federal government will look at your clients. And if your clients are getting federal money, we're not going to, we're going to interfere with your relationship with those clients. And that is a direct assault on one of the pillars of the rule of law, which is the legal profession. You go back 400 years. Henry VI, part 3, I forget which one, part 4, Shakespeare, writes about a claim that is being made by the Duke of York to Henry's entitlement to the English crown. And the Duke of York hires a person very appropriately named Dick the Butcher to stir things up. And Jack Cade is hired by Dick the Butcher. And Shakespeare, has a conversation between the two of them. First thing we'll do is let's kill all the lawyers. Often said as an anti-lawyer speech, but it is such a profound statement of the importance of lawyers to defending the rule of law. All autocrats, dictators, Stalin, Hitler, Pol Pot, Trump, understand that you have to be sure, if you want to actually keep the control that you want or expand the control to the level you want to have, you got to get rid of those people who can go into court and say to a United States district judge, yo, judge, you have the right to review the actions of this administration and determine whether they're consistent with statute and the Constitution. You get rid of the legal profession, you've undermined the rule of law. You attack the judges, like arresting this judge in Wisconsin. It's a direct assault on the ability of the legal system to function.
And I want to talk just in a moment about the judiciary and Trump's response to the judiciary so far. But, I think there's something more insidious happening here, because it's not only kill the lawyers, but he's actually forced them into giving him free service. So it's not about just like killing him. He's actually captured them. And now these attorneys or these law firms are going to be put in positions of, we saw an executive order on law enforcement, defending law enforcement officers that violate the Constitution. I mean, these law firms now are going to be basically, there to advance and protect the interest of Trump moving forward. So it's even worse than just killing the lawyers in this instance, right?
Well, it's sure. It's I don't know which is worse, but kill and co-opt.
Yeah.
Economic death.
Yeah.
I mean, they haven't killed any lawyers yet, but economic death and to co-opt. I mean, I could not believe that a couple of the large firms agreed to give, one was $100 million, one was even more than that, of pro bono services to the entities of Trump's choice. Meaning, you don't represent the aquarium in a Free Willy dispute. I mean, we had a huge thing in Oregon. One of the big firms here in town was involved with the orcas and in the aquariums. Well, given his environmental perspective, law firm who does that, that's not what Donald wants.
Mm-hmm.
And the executive order that came out about law enforcement, specifically said a direction to provide pro bono service to police and corrections officers who are charged with killing an inmate,
Hmm.
charged with shooting somebody on the street.
Hmm.
Uh, yeah, that's a problem. And another aspect of the assault on democracy, the rule of law. There are executive orders dealing with the right to vote,
Hmm.
repealing some of the provisions that expanded the access to voting booths, and the idea that your name has to match your voter registration on your birth certificate. Excuse me, what did the media reported? Nearly 70 million women have different names.
Hmm.
And what? They're now not going to be able to vote, or they're going to have to jump through hoops, which you have to figure, if only 10% of the women can't jump through those hoops, that's still 7, million women who are disenfranchised.
Hmm.
I mean, it's just another direct assault. And there's a perniciousness in some of this with respect to DEI for both the law firms, businesses, and the universities. I find it so offensive that they are using anti-Semitism as a wedge to curtail the university's abilities to do research without federal oversight, to cut off money for medical research, to dictate how and what the universities do in hiring, in setting up curricula. I find it exceedingly difficult to believe that they are genuinely concerned about anti-Semitism rather than using that as a wedge to force people back into other silos, if you will, a wedge between Jewish people, people from the Middle East,
Hmm.
Muslims, people from with the African heritage, et cetera, et cetera, et cetera. I mean, to use that, and now a proposal to have Jewish professors register. What in hell are they thinking?
Yeah. I mean, it's horrific, and I think you hit the nail on the head as far as how they're manipulating. I mean, turning everything upside down, whether it's civil rights, DEI, anti-Semitism, freedom of speech, freedom of religion. Everything's being inverted in a way to perverse sort of the meaning and understanding of what we've historically understood the Constitution to do, the Bill of Rights to protect. It's a remarkable thing, and the gaslighting around it is the thing that's very traumatic, because I think you don't know when you wake up what type of activity, action, or behavior is going to be considered criminal, or that you may be prosecuted for speaking out, for believing a certain faith, or acting a certain way. But we've kind of talked about the executive, and you mentioned Congress, and this is just an introductory conversation. There's a couple more issues that we want to dig deep into. One, which we didn't talk about, at the Federal Defender's Office, which you did a lot of, which was habeas petitions. So we'll talk, just introduce that, and then maybe in a different recording, go deep into habeas and what it means and the importance of it. But one backstop right now has been the judiciary, the federal courts. But we are starting to come to what I imagine is an inflection point, because we are clearly in a constitutional crisis. The Trump administration is, at this point, dancing around judicial orders and ignoring them, not following them. But it's still not an outright middle finger to the court. I mean, we're pretty close to it, and as you mentioned, the Enemies and Alien Act, like there was a court order that came out today that said the invocation of it was it's improper. And so the next question is, this is going to go up through the appellate system, and at some point that there'll come a time where the Trump administration just basically says, F you to the Supreme Court. I mean, I think he's already done that in many ways, but it'll be more explicit. But can you talk a little bit about right now the role of the courts, the trajectory that we're on, and what happens when we reach that inflection point and this administration does do that? I mean, what happens to our democracy and, again, the rule of law at that point?
Another great question, Bobbin. What happens? Uh, Nobody knows, because we have not been in a situation remotely like this since the first couple of decades of the 19th century, when the notion of judicial review by the Supreme Court, that is, the Supreme Court as the final arbiter of what is or is not lawful or constitutional, was being settled. And there was famous Chief Justice back then, John Marshall, one of the giants of the legal history of our country. Supreme Court issued a ruling that wasn't well liked, and someone says, "Well, John Marshall has issued his ruling. Now let him enforce it." So that was early on. Andrew Jackson, when he was president, I guess 1830s. I mean, there was some tension around stuff that Jackson was doing, and didn't comply with. With those exceptions, and particularly in the modern era, it's been understood that the Supreme Court is the final arbiter. I mean, we only have to go back, to the 1930s and the Roosevelt, administration and Congress, action. They're passing the National Recovery Act. They were passing any number of statutes to address the Great Depression, and the Supreme Court ruled in a number of instances that those statutes were not permissible, exercises of congressional power under the Interstate Commerce Clause that in the Constitution gives Congress the power. 1936, I think it was, there's the famous saying, "A switch in time saves 9." President Roosevelt and the Democrats in Congress were very frustrated by their inability to have their Depression era statutes carried out, because the Supreme Court, after a couple of years, would say no. And one of the justices, and there were 5-4 decisions, one of the justices switches, and things start coming out 5-4 the other way, and then 6-3, blah, blah. And Roosevelt's approach to this had been to foment for expanding the court. The switch in time saves 9, the 9-member court from the foundation of the country. The idea was, let's expand it. President Biden had also, brooded about the possibility of expanding the court with some of his frustrations, but that didn't go anywhere. People understood across the board, wherever you are in the political spectrum, that the court acts, you comply with it. Mm-hmm. What we're seeing now is different. And the Supreme Court did say that the removal of Mr. Abrego Garcia to El Salvador was not lawful. That because he was seized in the United States, he was entitled to due process under our Constitution. No exception in the due process clause. You're a citizen, you're not a citizen, you got a green card, you don't have a green card. You're entitled to process. Mm-hmm. And the Supreme Court said he was entitled to process. The remedy that they gave was wishy-washy. They directed the Trump administration to facilitate his return. Now, a president who is honoring that would have gone back to his office, picked up the phone, and said to the dictator of El Salvador, with whom he has contracted to hold these people, send this guy back.
Mhm.
And you can bet your bottom dollar that that man would have been back immediately. Well, the administration has been directed, when the case went back to the lower courts, to provide updates. What are you doing to facilitate? And they have stonewalled, and they have asked for delays. And that issue is coming to a head again. It should come to a head in an even clearer way, because in an ABC interview a day or two ago, the president said, yes, he could call and get Mr. Abrego Garcia back, but he won't. Now, that seems to me to be directly flouting the authority, the order of the United States Supreme Court. And my question to the 9 justices of the Supreme Court is, what are you going to do about it?
Mhm.
And this gets to your question, Bobbin, because throughout all of the lawsuits that have been brought since Trump took power, and some were filed even before he took power based on what he said he would do, 85% of the lawsuits, whether it's to fire federal employees, whether it's to cut research grants, whether it's to interfere with labor relations, the deportations, across the board, the Trump administration has been losing. But the federal employees have not en masse been rehired and put back to work. In some of the agencies, they have been put back on the payroll, but on administrative leave. So the function of the agencies has not resumed.
Mhm.
And the question, what happens? John Roberts, the Chief Justice of the United States Supreme Court, I hope sees that there is, if you will, an upthrust finger being pointed at him by the administration. When the president says, I could make the call, but I'm not doing it, that's not facilitating. So what happens? The judiciary has contempt authority. The judges, district court, court of appeals, and Supreme Court can hold any member of the administration in contempt. Yeah, if I'm litigating in the court, they could have held me in contempt. Some of my colleagues in federal defender offices were held in contempt because they did not act in professional and appropriate ways. There are little jail cells in the federal courthouses. The United States Marshal's Office service is charged with providing security to the federal courts. The district judges, as a general proposition, routinely issue orders to the Marshal Service. Well, what's going to happen when a judge issues an order to an assistant U.S. Marshal to go bring into the courtroom some member of or lawyer of the Trump administration? Secretary of State Rubio. If he's the one who is supposed to be facilitating, and he's not, will the Marshal Service honor the judge's order? Or will the Marshal Service say, no, my boss, the head of the Marshal Service, is an employee of the Department of Justice, and Donald Trump and Attorney General Bondi say, nope, I'm your boss, not that judge. Now you have a genuine, immediate constitutional crisis. And regrettably, everywhere in the world, when that occurs, the person wearing the largest gun wins. And I hope to God we don't get there. I hope that the president himself understands he is not a king. He doesn't get to say, do it because I say so. Take it back 20 years, Bobbin, and to the Guantanamo litigation. My old office got into the representation in 2005. We represented 6 people. We filed all sorts of pleadings in the district court in Washington, D.C., in the Court of Appeals there, and amicus briefs in the U.S. Supreme Court, and did strategy work on some of the other Court of Appeals and Supreme Court litigation. The essence of President Bush's argument was, as the president, I have the authority to order the seizure and detention of enemy combatants anywhere in the world and hold them without process. Enemy combatants, I mean, people engaged in fighting against the United States. And the people in Guantanamo, some were actually picked up on the battlefield in Afghanistan. Others, like one of my clients, was arrested in his apartment in Peshawar, Pakistan. He was a hospital administrator. Others were seized in Bulgaria, held in CIA sites, and then brought to Guantanamo. The first question that had to be decided was, even for enemy combatants, once you're brought into the jurisdiction of the United States, do you have a right to process? Or can the president say, I say so, you were an enemy combatant, I brought you here? First aspect of the litigation was, is there jurisdiction for habeas corpus in Guantanamo? Answer, ultimately by the U.S. Supreme Court, was yes, because it is U.S. territory. There was jurisdiction. In the decision that ultimately resolved the constitutional question in 2008, Boumediene versus Bush. Boumediene was an Algerian fellow who was in Guantanamo. Justice Kennedy, who was not, as is often perceived, a particularly progressive or liberal judge, but he understood the fundamental importance of our judicial system, our legal system, our governmental system. When he wrote that opinion in Boumediene, he gave us a history of the writ of habeas corpus and the power of English kings that was taken from them in the 1600s. And he said, cutting through all the legalese, President Bush, the power you're asserting was a power asserted by the English king that was taken from him by the English through the writ of habeas corpus and the parliament 400 years ago. And President Bush, you don't have that power. That's the fundamental issue that is once again in play. And it is the power that President Trump is asserting in different contexts. I'm the president. I got to say what the law is. I'm the president, and I can throw these people out of the country, and judiciary, you can't stop me. President Bush in 2008, when Boumediene was decided, recognized that, these guys now have a right to hearings. And, very shortly after that decision was handed down, Steve Sadie, chief deputy in the defender office, and I were in district court in the District of Columbia litigating habeas cases on behalf of 2 of our clients who were still in the prison. And the Bush administration attorneys from the Department of Justice were there advocating for, a number of reasons. These guys shouldn't be let out. He's really a bad guy. He's really a bad guy. But they didn't say, nope, sorry, Judge, you don't have authority to hold this hearing. And that's where Bush and Trump appear to be on a very, very divergent path.
As I mentioned, I think in one of the follow-up recordings that we'll do is dig deeper into habeas corpus and the importance of it and why it's such an important tool and for individuals, for detained individuals, and why it's such an important, especially in this moment, to be able to have access to the courts, to be able to file habeas petitions and what it means. But just to wrap up, I think like we've introduced a lot of different issues and topics, and one of the things we just talked about was sort of this attack on the judiciary. What I was going to talk about or asked to talk about a little bit is, Trump through his social media, attacking judges, Article 3 judges, criticizing them, calling them names, asking for their removal, essentially, arresting this judge in Wisconsin. So it's not just about ignoring orders, but he's actually attacking the judiciary, lodging. And we know like what his followers and all the people who listen to him do. I mean, these are basically calls to violence, essentially, against these individuals, to target them, harass them, threaten them. But just, I guess, lastly, we've talked about all these executive orders and some of the most heinous examples of people being renditioned out of the country, kidnapped, under the guise of being removed or deported. All this that's happening with the reorientation of the Attorney General, the FBI, the abdication of Congress's role, the attack on judiciary, these questions that we're starting to see, right now it's being targeted and limited to just a small number, so to speak, of people, or people that have less rights than us, U.S. citizens. It's focused on non-citizens, and that seems to be, where the test of power is happening. But people should be concerned because the way they're defending this power means that it could be applicable to anyone or any individual. Can you kind of talk to just help us wrap up here, just talking about like why these questions that are coming to a head are so important, but they're right, being played out in sort of a more, I don't know, in a very targeted way, but what should we be afraid of as we move forward?
We should be afraid of everything, Bobbin. The attacks on Columbia, Harvard, Rutgers, Northeastern, Northwestern, those aren't attacks on non-citizens. Mm-hmm. Those are attacks on core institutions of our civil society. The defunding of studies of medical studies is not an attack on aliens. Mm-hmm. Cutting the funding here in Oregon for the NOAA facility in Newport on the coast that alerts us to tsunamis, watches when are the whales, what's the fishery, do we have a big hurricane coming in? That's an attack on the core of American society. The people who are being fired, let go, made fearful in their federal jobs, those are not the poor, the downtrodden, the huddled masses yearning to breathe free, who used to come to this country. That's everybody. That's every person in this country is being harmed by the way in which the administration is acting. To be sure, the immigration statutes, the removal of people from this country to foreign prisons and to local prison hellholes run by ICE, and private contractors are now jumping all over themselves to build new facilities. To be sure, those people are not citizens of the United States, although some citizens have been rounded up. Mm-hmm. 2-year-old, 4-year-old, 7-year-old, who's got custody? They don't care. They're just gone. They're taken out of the country. So I don't accept the premise in your question.
Yeah.
I also want to respond to the question by saying that the principles, and I think this was inherent in what you said leading up to the question, the principles that the administration is relying on, if accepted with respect to a green card holder, could very well next be advanced against a citizen. Perhaps they'll go first to naturalized citizens. Maybe Elon Musk will be seen by President Trump next year as an enemy, and they'll find some reason to go after his naturalization process. And then maybe it's the people who were born in this country. Birthright citizenship, yeah,
Mhm.
their effort to say that the 14th Amendment provision that says if you're born in the United States, you are automatically a U.S. citizen. Well, so if they prevail on that, is that retroactive? Is that only people who were born after birthright citizenship is declared not to exist, or can they go back? And how many generations can you go back? I suppose you can go back, even to the first, Native American ancestor who walked across the Bering Sea, whatever it was, 9, 10, 12, 20,000 years ago. How far back can you go? Where's that line going to be? So the principles in terms of this deportation removal stuff, lack of process,
Mhm.
that can be applied anywhere that a dictator wants to apply it, and in any way that a dictator wants to apply it. There's nothing that I see, and one of the things that I have written about in the book I wrote about this stuff and all the talks that I've given, in the U.S. I mean, hundreds of times since 2004. I've spoken in the U.S., in Germany, in Ireland, in Sudan, and about the threats to democracy, which I saw as real from Brandon Mayfield's case, 9/11 stuff on have. Let us just hope it doesn't come to that. Let us hope that the people in the administration come to their senses, recognize that we do live in a democracy with 3 branches of government and 2 layers of government, and that they honor the orders of the courts.
And to be fair, I welcome your rejection of my premise because I think the point that you're making is the actuality of where we need to be in and understanding that there is an all-out attack on everybody in every shape, way, or form. And part of like what's going on with the dismantling of the federal government, the dismantling of oversight structures and accountability, is that that's all that's really happened. Like he's dismantled the federal government to prevent the implementation of a political agenda. So now, there's no oversight of law enforcement, no oversight of the carceral systems, no oversight of the executive, from the federal government, no civil rights division, right? No agencies to regulate environmental things or, whatever it may be, the impacts with NOAA. I mean, now there's nothing there or there's less there, or perhaps nothing there that provides that oversight. Now it creates a vacuum for, the full on sort of political agenda to be implemented. And it's all written in Project 2025. I mean, was all written and put out very clearly before Trump was elected. But yeah, I think also as a follow-up, it's the principles that I'm talking about. And I think this is the thing that concerns me the most is the continuing sort of push and prodding and testing of these powers. How much are we going to withstand? How much are the American people going to stand by and at some point just be like, enough, never mind, he keeps pushing and pushing and pushing, and people get used to it and normalize to these new behaviors, these new powers, the way in which people are being pulled up. And right now, I just got to say, I'm extremely grateful for all the national organizations that are out there litigating these things, litigating these issues and winning. As you said, some 85% of the time he's losing, and the federal courts were standing up, and federal judges of all stripes and political ideology. It's not, as Trump would have it, radicals or left-wing lunatics in the court or anything like that, but it's Republican, Democrat, conservative to, what they would define as liberal judges, trying to put a stop to this. So, well, as I mentioned, this is just an introductory conversation. And, I really appreciate your time to kind of give us an overview and some historical backgrounds and some general thoughts on what's going on. In the next recording, the next interview that we do, I'd really like to dig deeper, like I mentioned, into this concept of habeas corpus and why it's important, and due process, and talk about that. Because I think these are two things that help protect our democracy and are tools that prevent oppression, a dictator just basically summarily throwing people in detention indefinitely. These are the things that, I feel incredibly nervous and anxious about at this point as to the elimination of due process. And, right now we'll see how effective habeas will remain. But once these two go away, we're really in a very different sort of nightmarish dystopian kind of situation. So I don't know, any last thoughts?
When we talk again, Bob, and we should also talk about the parallels between what happened in Germany with Hitler's use of Article 48 of the Weimar Constitution and the doctrine of exception and reliance on national security and national security emergencies to justify what the Trump administration is doing. There's a very chilling parallel there to the use of the law to eliminate law.
Well, why don't we start then at our next recording? And as I mentioned, this is a series, so we'll continue this conversation and continue to talk about these issues and topics as they emerge. This week, we're also launching a new website called We Must Dissent. It'll have news and resources for people to be able to track things that are going on and the impact of the Trump administration. And on that, too, we'll have some original commentary and writing from Steve up on blog posts that you'll be able to access. So stay tuned for that. And join us next time for an episode of Trailblazing Justice. Thanks to Steve and to our producer, Todd Davila. We'll see you soon.
Thank you, Bobbin.
Thanks.